For most cases in Florida, you have 2 years from when you knew or should have known that there was malpractice. We urge people not to wait if you suspect anything. Obviously, if damage has already been done, that's a trigger date. If somebody passed away, it's 2 years from the date of their passing. But if you've sustained something that you know is a significant injury, then waiting is really not an option because that 2 years will rapidly approach. During that 2 years, you have to retain experts and you have to put the other party on notice, and then you have to wait for a period of at least 90 days, sometimes longer, while that case is investigated before you can actually take legal action and formally go to court on the case. And so 2 years is the rule. The exceptions to the rule are involving children sometimes and discovery of the injury. Sometimes injuries are covered up. There may be fraud, there may be other extenuating circumstances, but that's really not the norm. And then children have a little bit longer when they're minors until they reach certain ages, because sometimes birth injuries, for instance, which are catastrophic, you don't even know how permanent the injury is. With certain types of birth injuries, cerebral palsy, other types of injuries, the doctors, the neurologists say that we can't pin a definitive diagnosis on these injuries until later. So we've got cases we look at very frequently with birth injuries where we want to review everything early, but we're still kind of waiting, and it's a process for the parents. It's heart-wrenching when they see their child's not exactly right and they know something was done wrong, and we're in a kind of a wait-and-see approach. But the sooner you approach us here at Fair and Fair and let us evaluate things, the easier it is to comply with that very, very strict 2-year statute in most cases.